What's up, everybody? We are back with another hearing in Sarah Boone where she is complaining about her lawyer. This time, we hear her complain about her snotty attitude, being a liar, mistreating her, not doing what she wants her to do. And she's written another letter, and it's a long one. We're going to react to this hearing. We're going to watch what the judge says and see what's next for Sarah Boone amongst all the chatter. This is a good one. You're not going to want to miss it. This has potentially been one of the wildest pretrial attorney-client cases I've ever seen, read about, heard, witnessed, whatever it may be. And if you compare it to trials like Koberger, also the public defender, also appointed counsel, way less issues. If you apply it to or compare it to cases with private counsel, very different. And Sarah Boone has just made her way through 7 different lawyers for all sorts of different reasons. We've had complaints of lawyers being a buffoon, of not answering her phone calls, of not working on her case, of being lazy, of ignoring her, of not listening to her. We've had conflicts of interest from certain lawyers that have had to get off the case. We've had irreconcilable differences. We've had Sarah Boone asked to keep certain lawyers and then get rid of certain lawyers. We have had basically everything you possibly could have when we're following a case through the pretrial phase, right? And people are comparing her to Daryl Brooks. In some aspects, she's better than Daryl Brooks, obviously, but in some aspects, she's worse. And at some point, something's going to have to give. And so we'll talk about what that is when we eventually get there. I think there are some lawyer pop-ins here on this Court TV broadcast. So we're going to watch it together. We'll listen to what these lawyers say. We'll give our reactions, whether we agree or disagree, and what we think is going to happen now with Sarah Boone if she tries this yet another time.
And Sarah Boone is in court. This woman is accused of getting her boyfriend to crawl inside of that suitcase, zipping it up, and then leaving him there to die. She was arrested in 2020. Her case has experienced numerous delays, most of them caused by her, because she either fired her attorneys or they quit, perhaps because she was intolerable. Let's go into the courtroom together now. Her latest attorney is addressing the court. Let's watch together.
Judge, I've obviously not seen the letter. Ms. Boone is correct. She has walked out of the last 2 visits when I've tried to review things with her, just so the court knows.
So there's our first indication, and there's lots of parts. It's not the whole hearing for whatever reason. I can't find the whole hearing, but this is the most of it. But Sarah Boone has walked out of the last 2 meetings with her lawyer. So she spent months complaining about Bankowitz not showing up, not meeting with her. And we talked about it. That's not acceptable. We can't have that in the system, even if you're a horrible client, even if you're a horrible person, even if you're intolerable. Well, we're going to listen to this hearing today. And if you want to know how a lawyer should act with a difficult client in dealing with this situation, in my opinion, this lawyer did it. She spent hours in the short amount of time that she's represented Ms. Boone. She has gone to numerous meetings with her. She has accepted collect phone calls. And how does Sarah Boone treat her? We're going to hear more, but we know she is literally walking out of meetings. Now, we're going to read between the lines on some of this and why we think Sarah Boone is so upset and what this says about her case potentially and the strength or weakness of her case, or maybe the strength or weakness or truth of some of the arguments she wants to make. We're going to keep that in mind as we listen to what's going on in this case.
I've spent probably 20 hours, a little bit more, a little bit less, with Ms. Boone. She has lots of lists, lots of questions. In reviewing the court file, she was distressed previously about having access to her lawyers. I have taken collect phone calls from her that are at my expense. JC doesn't reimburse you, because I think it's important for clients.
So if anybody has a problem with her saying that, like a couple bucks here, a couple bucks there for collect calls that she has to pay, boo-hoo, she's a lawyer. Well, spending money to represent somebody like Sarah Boone is different than taking lesser money for being court appointed. So she does have a point that she's trying to make sure Sarah Boone has access to her, so much so that she's accepting and paying for collect calls and going to visit with her multiple times, clearing her schedule, not working on other cases. So she, again, is doing what a good lawyer should. She studied the files. She saw what some of the complaints were with other lawyers and wanted to make sure she doesn't make or create the same issues with Sarah Boone. She's not going to be the problem. It doesn't work out. That's what this attorney is saying.
Clients to have access. I have
Hang on,
spent,
please. No one's interrupted you this morning, Ms. Boone.
as I
Judge puts his hand up like, not right now, Sarah. Not right now.
said, I've spent over 20 hours going through her questions, going through her list. When I tried to update her with regard to the depositions that I took recently, she opted to exit the jail conference. When I tried to review some things with regard to discovery as to things I wanted to make sure she was aware of, she walked out.
So we went through discovery together. I showed her some things that I wanted to make sure she was aware of. Now, I'll tell you, just from my perspective, I'm not guaranteeing that's what happened in this case, but if I have a conversation like that with a client and they walk out of the room, usually it's because I want to make sure the client is aware of issues in their case, potential problems in their case, maybe inconsistencies in their case or their testimony or what they think happened or what they say happened. Because if you have a client that keeps telling you one thing or keeps telling you this is how it is, or they can't prove this, or I didn't say that, she's like, well, here in your police interview, you very clearly say this, and Sarah Boone gets up and walks out. Well, that creates a situation where you can't represent her because you can't fully prepare, and she wants you to do and say things that you don't want to do that are in dispute with the evidence, and that creates issues. And that's what I'm hearing when I hear the lawyer make comments like that. Robin said, question, what can the judge do if she refuses any more attorneys? I mean, if she wants to represent herself, I think at this point the judge would allow her to. We'll get into whether or not he's going to force her to. Mindy, I already know she's going to end up representing herself. She doesn't like what they tell her, whether it's the truth or not. We have another Darrell Brooks here. I think she does want a lawyer. I think she wants a lawyer to prepare and argue the case the way she wants them to. And that's been the problem. I don't think she wants to do this herself. I think she knows how that will go. She already tried that with the cops and it didn't go well. Holly, how many public defenders is a person entitled to? Peter, can someone finally say it's not me, it's you? So yes, this is the big question. When is enough enough? When is the judge going to say no more court-appointed lawyers, no more lawyers that the state of Florida is going to pay for? You do it yourself, or you come up with money to hire a private lawyer, or you make it work with a lawyer. And the truth is, forcing her to represent herself is like beyond the last resort, because we all know, and judges usually advise against clients representing themselves. What I expect and what I think the enough is enough situation would be is, Ms. Boone, you either make it work with this lawyer or you represent yourself. So you are making the decision. Do you want to work with this 8th or maybe 9th lawyer if the judge lets her out of this one, or do you want to represent yourself? That's what I think it's going to come down to. Nina, Peter, do you think Sarah is unconsciously delaying because going to trial would mean she's found guilty? Better to keep the process going? Maybe. And there's going to be some discussion about her getting out. And I think if she gets out, this is exactly what she would do. But I really, truly believe she thinks, and it's kind of like, with children, and I don't mean to be demeaning, but if I tell my son no, and then he asks me a second time and I say yes, well, next time I say no, I can almost guarantee he's going to ask me a second time. And if I say no a second time and no a third time and then yes a fourth time, now he's going to ask me 5 times that I'm going to have to say no. So Sarah Boone's already been able to switch lawyers 7 times. Is the court going to let her do it an 8th time? And if so, she's probably going to continue doing it until she realizes yeses are yes and no's are no. And I don't blame the court, because I would have done the same thing for the most part, because you really want to protect a defendant's right to a competent counsel, fair trial, right? That's really what we want to do. But I mean, there are lines. There are lines. Where it is kind of a gray area and up to the judge.
She has asked me repeatedly for a copy of some medical records. Based on the discovery I got from the previous attorneys, one of the copies of those medical records had her handwritten notes. So she had a copy given to her previously. She'd reviewed them with previous attorneys. I sent her a new copy.
So she has repeatedly asked for certain medical records as if she didn't have them. And when this attorney was looking through the discovery, clearly proving she actually is doing that, she found out Sarah Boone, in fact, has seen these medical records. And how do we know that? They have Sarah Boone's handwriting on them. So maybe some of the comments about not seeing any of the discovery or never seeing what's going on in the case, maybe some of that's not true based on information we have now. If it is true, we always said that's a problem. Do we know Sarah Boone is telling the truth at any given moment? No, of course not. But criminal defendants are entitled to see the discovery and evidence against them. They're entitled to talk to their lawyer. They're entitled to be involved in their defense. But it seems like maybe she's been a little more involved than she was letting on in some of her letters.
Some of the things that she thinks are important from a lawyer perspective, perhaps I don't attach the same importance to, and you try to explain that to a client. I know the court's in a
And again, she's like, there are certain things Sarah Boone thinks are more important. Certain things I don't think are as important. Same thing happens with me and my clients. And they choose me as their lawyer, right? It's very different than court appointed. Sometimes the clients can be a little bit more disrespectful in court appointed cases. But even in clients that choose their lawyer, we have disagreements on what's more important, but we trust each other. We work through it. We talk through it. And usually I can explain why certain things I think are more important than others, or I'll say, okay, we'll give a little bit more credence to that because you think it's important. Maybe a jury would too. So these are discussions that are not uncommon, that part.
difficult position, but at this point, we're at that impasse of if she walks out of every conference that I have with her, I'm not sure what that says about the attorney-client relationship.
Ma'am, you said there was something else.
She says it puts the judge in a difficult position because we're at that impasse where Sarah Boone keeps walking out of our conferences. So obviously we don't have a very good attorney-client relationship. So what she's saying is, I don't think I can represent her, judge, which puts you in an impossible position. Are you going to appoint ninth counsel? Are you going to force me to stay on the case even though I've told you there's a fracture in our relationship? Or are you going to force her to represent herself? None of those are great decisions for the judge. All of those create appellate issues. June, she wants a lawyer who would portray her as she isn't, and evidence shows that she mocked him, right? I don't know if they want her to portray her as she isn't, but I definitely think she wants them to make arguments that they're thinking that's not possible or that's not correct. Or maybe it's not about the trial at all, which we're about to hear some of the other things Sarah Boone is annoyed about. Terry, hi again from England. I bet this is a wild show from England, right? Peter, how much longer is this going to go on? Waste of the court's time and lawyers exasperated. But if Sarah Boone represents herself, it would be a nightmare. I agree. If I think the best case scenario is her saying, I want to represent myself. I waive my right to counsel. Let's go to trial because we can actually get it done. But as long as she says she doesn't want to represent herself, there are all sorts of appellate issues all over the place. Now, I'd be willing to bet that any appellate court that looks at this case will realize the defense attorneys and the judge and the system tried their best. They gave her 9 different lawyers. They forced her to keep, or maybe if let's just say it's this one, say it's lawyer number 8. If they force her to keep lawyer number 8, it is what it is. And she was doing this in bad faith, or she can either represent herself, have standby counsel, whatever it may be. But at some point, I don't think an appellate court's going to say you have an unlimited amount of defense attorneys and the victim has rights and their family has rights to get justice. And you can't just continue to do this forever and ever and ever as a criminal defendant. So we'll see kind of how that goes. Pesky Pirouette. Can the judge tell her she won't be getting credit for time served? Does she like the jail? Is she blaming attorneys when they are not the problem? So almost always they get time served. And there are some very, very heavy potential sentences coming down depending on what she gets convicted of, if anything. So I don't think they would threaten something like that. But of course, she's blaming all of the attorneys. I think some of the attorneys were probably a problem, but definitely not all of them. And this attorney definitely doesn't seem like she's been a problem so far.
Else that you had other than a 58-page submittal or letter? What other information is it that you're seeking to have me take a look at?
It's things that I've been working on in the meantime.
58-page letter, folks. That's going to have to be like a 5-part video for us. I mean, 58 pages. What the heck could be in 58 pages? And listen to what she says during the meeting. It's like, to say all this doesn't take 58 pages. By the way, make sure you guys hit that like button. Make sure you subscribe to our page, because when this does go to trial, because I do think it will go to trial, I'm going to hop over there and check out some of it live. And our recaps are going to be just even that much better.
It's things that she likes to tell me is not necessary, but I know for a fact it is necessary. She likes to, in quotes, put things to rest all the time and constantly tells me I'm not having this conversation with you. So I'm not going to waste my time, and I, being in jail, has supposedly abundant amounts of.
So she says she refuses to talk to me about certain things. She says, I'm not having this conversation, and she wants to waste my time, which I don't want to, but I am in jail, so I have an abundant amount of that. These are how their conversations go. So just imagine it. Nina said, Peter, how would you deal with a client like this? Well, thankfully, I'm blessed to choose my clients and have my clients choose me. So if a client really treated me like this or felt like the relationship was like this, that would be the end of it. And if I don't feel like I'm a good fit for a client, I will withdraw. And it's great because in most of the cases, clients don't pay me anything up front, right? So it's a vibe where we got to work together. We want to work together. We are mutually beneficial to each other. There's a lot of trust and respect that's built up. Doesn't mean we always agree. Doesn't mean that things sometimes don't get in difficult positions. That happens in plenty of cases. But if it's built on trust, usually you can get through most of the difficult times of a trial, because it's a very difficult and stressful time. So glad to catch you live. Why is Sarah so difficult? Kim, this is the $1 million question, isn't it?
She's not going to waste my time because she's not going to explain something to me. And I have taken.
Like, the judge has to be like, ma'am, do you realize how disrespectful you're being? She's not going to waste your time by explaining something to you, but she wants to explain other stuff to you and you walk out. How do you think that helps you in your case?
Upon myself to explain it to myself because she refuses to do so. I don't understand what it is that she has against me. I have told her from day one that her snotty attitude was inappropriate.
I don't know what she has against me. I told her from day one that her snotty attitude is not appropriate. So imagine that. And I can imagine it since I'm, in fact, a lawyer. But for any of you guys that have jobs, imagine you show up day one and she says, this snotty attitude is not appropriate. I would say, excuse me, ma'am. I would say, okay, I apologize. I didn't mean to act snotty, and I would try to make it work. But that would be in the back of my mind basically the rest of the time if this is how she treats people who are trying to help her. This is how she treats people that are on her side. So you can imagine how she treats people she doesn't like or that she doesn't need. Right? Whew. I mean, people are saying, Peter, you defend her. No, thank you. Pass. It is a service of public defenders and court-appointed attorneys. I respect them for it. It's not my path, not my journey. Carlos, childish, defiance, denial, or mental illness. I have no idea, but I definitely think it's got something to do with her narcissism and how she thinks about herself. Randy said, hi, Peter, I have a couple contract questions. Could you help me with the answer? Where would be the best place to send them? So I don't do contract work specifically. We focus on wrongful death cases, personal injury cases, car accidents, trucking accidents cases, all over the country. We handle those and help people with those. A lot of people that have found us on YouTube, which has been so awesome to work with them. And again, the attorney-client relationship has been great and starts out on such a great foot for people that find us on here. If you want to email me what state you're in and what kind of contract questions, I can see if I know a lawyer in the area I can refer you to. Be happy to do that. SN, Peter, in your opinion, do you feel there is enough evidence for second-degree murder? I got to be honest, I just don't know all of the evidence yet. I think there is a chance. I'm not going to say guaranteed, but I think there is a chance to prove that. I do. And then I think there's a chance that it's some kind of manslaughter or negligent killing charge. That's what I'd be more confident in if I was the prosecutor, but I want to see what evidence comes out of trial and what the experts say. Labyrinth. Hi, Peter. Sorry if this was asked. Would the multiple attorney issue help prosecution in any way? No. Definitely shows a history of combative behavior. No, it really doesn't. If anything, maybe the judge is really annoyed with her and he's going to hit her with a harder sentence than he would have. But from a prosecutor's point of view, it's frankly annoying. You got to have the same conversation with each and every lawyer that comes in and out of that office, re-explain discovery, retell them, what happened before with the last lawyer. And nobody likes wasting time like that.
And I try very hard to bear with her and her attitude. I don't know what it is that I'm doing wrong to her, but I feel that her attitude has equal prejudice, which is not in my favor, especially considering she's supposedly representing my life.
Her attitude has resulted in or felt like prejudice. Okay, these are buzzwords. These are appellate words. These are dirty words the judge doesn't like. And that's why the judge is put in such a difficult position. And it's frankly annoying that she's doing it this quickly with lawyer number 8. It's like she has no care in the world that at some point somebody's going to tell her, no, Sarah, that's it. It's over. It's done.
Okay. Give me an example of, if you could, of items that you believe are important Ms. Cashman is not giving attention to or dismissing as you may have framed it.
Yes, Your Honor. She likes to tell me that I don't like her answers. She's not giving me any answers to this. I've written 3 pages worth of questions, but I'm still waiting for her and any other attorney to actually answer for me.
She's not giving me the answers to questions that I have. I have 3 pages of questions written. I'm assuming that's in the 58 pages. Eventually, we're going to see that, I think.
Such as, why can't I have a bond? Why can't I have a download of my phone? Why can't I speak to my investigator?
Why can't I have a bond? More on that later. And I think that's probably one of the things where these lawyers are being a little dismissive, like, ma'am, you're not going to get a bond at this point.
Can't I have my medical records? Why can't I fully utilize my constitutional rights? There's 3 pages worth of questions that I have.
What constitutional rights specifically?
The judge knows what's going on. He's like, why don't we document this? What constitutional rights are you talking about, ma'am? What is she not allowing you to do?
I'm very leery about having a fair trial at this point. There can be other amendments that I have been researching and working on or trying to incorporate. To me, what I have written to you is obvious, and apparently from the correspondence that I get from the world, South Korea was the last place that I received correspondence. They obviously see the same thing.
She's getting correspondence from South Korea, and they agree with her. Her constitutional rights to a fair trial, that's becoming a problem. And again, another word the judge doesn't like. I'm going to back it up there so you can hear her again talk about her correspondence from South Korea.
Why can't I fully utilize my constitutional rights? There's 3 pages worth of questions that I have.
What constitutional rights specifically?
I'm very leery about having a fair trial at this point. There can be other amendments that I have been researching and working on or trying to incorporate. To me, what I have written to you is obvious, and apparently from the correspondence that I get from the world, South Korea was the last place that I received correspondence. They obviously see the same thing. So
the world agrees with Sarah Boone, and she has sent that to the judge, and the judge should listen because the world agrees with her. That's what she's trying to set up here. Yellow pill. Could the lawyer be allowed to handle the case without her input? Several have mentioned unreconcilable, I think that's what that means, ethical issues. So yeah, I mean, no, they're not going to let her lawyer just ignore her and not allow her to participate in her defense. They'd let her represent herself before that. That would be too drastic of a measure, and that would violate her rights. And if she can't come to a lawyer, then basically she is ipso facto deciding to represent herself. That's where it may come down, but we'll see.
I don't know what I'm doing wrong other than wanting to have a very successful outcome. It's just been long and drawn out, and I believe that God obviously believes in me as much as I do in Him in order to give me this very unique adventure that I am on, and I'm doing my best to let everyone know who I really am as opposed to the malicious murderer that everyone thinks that I am. I don't feel that she can do that properly.
She needs everybody to see her for the person she is, not the malicious murderer everybody thinks she is. So is that what the world is saying? I don't know.
I still always, the reason why I'm here is hope. is to hope that she will come in with a gentle, soft aside and actually listen to what it is that I'm saying and see the bigger picture other than what the one avenue that she keeps going down.
She hopes she can come in with a softer, gentler attitude. So basically, what Sarah Boone is doing is she thinks she's going to have the judge reprimand this lawyer in open court and tell this lawyer to be nice to Sarah Boone and listen to her and do what she wants. Clearly, the lawyer has a strategy. She has one specific avenue she wants to go down, which is probably telling Sarah Boone what her best argument is to win this case, or at least get a lesser charge. And Sarah Boone is not happy with that. Even if she could win, she wants the world to see her as a good person, not a bad person. That's what it seems like. And I got to be honest, that's not that uncommon. Sometimes clients care more about the principle than the case, and that's sometimes the most difficult type of case to work with. Yellow Pill said, but is that worse than forcing her to be pro se, meaning have her lawyer represent her and just ignore her? Yes. Yes. Ignoring her and not doing her wishes. She usually in our country, we let people go down with their own decisions and wishes. We don't remove them from their own process and force them to just take my argument that they don't believe in, agree with, or care about and force that on them. I get what you're saying. Like, logically speaking, this lawyer's argument is probably better and gives her a better chance to win and is actually better for Sarah Boone than what Sarah Boone wants. But we don't force that on people. We basically let people lay in the bed they make. I probably messed that one up as well, but I think you get my point.
There's other ways to win in more than one way. I'm not sure what I'm supposed to do, but I'm not saying that I'm trying to remove her. I'm just trying to ask you, please, forgive me for having to ask you for this. If you could please let her know, please, to just be nice to me and have a welcoming attitude, and things will probably change, and I will not get up and I walk out. Please don't lie to me. Please don't give me half-truths. And
What instances where there's been falsities or lies that have been told to you by Ms. Cashman? Can you give me an example?
my biggest one, Your Honor, is for me being here.
She called her a liar, and he's like, tell me where the lie is. Show me where the lie is. She's like, okay. And then she looks up in the air to try to find a lie, and let's see what she comes up with.
Ongoing 5 years, no one has ever bothered to try to get me a bond.
What's the lie? You said that she has lied to you.
What's the lie? She refused to try to get me a bond. It's not a lie, ma'am.
What is the lie?
The process of getting a bond. She lied to my brother in regards to telling him that he would need to come down to the courthouse to have multiple photographs taken for documentation, and he would have to bring the security information deeds to his house.
Oh my.
There's a lot of random breaks. I don't know why, but basically she's saying that there can be a lot of different processes to getting bonds, by the way, and getting them paid for and secured and things like that. But she started talking about how she lied to her brother about the bond process. Let's hear what these attorneys talk about. We can react to it. I don't think it's very long. And then we get back in for more of the hearing.
So much to say here. Where do we begin? Let me bring back in my friends, Tommy Pope and Michael J. Brown. Okay, so we're on lawyer number 8. God bless this woman, Patricia Cashman, the attorney. We just saw the back of her head, the blonde curly hair, addressing the judge, saying she spent 20 hours with Sarah Boone. She's even taken collect calls at her own expense. She serves with the Office of the Public Defender there and has taken calls that she's had to pay for out of her own pocket when she's not making a lot of money, because she wants to be devoted to her client, and her client is walking out of discussions with her, and they have reached this impasse. Tommy, Sarah Boone has had a problem with every single attorney. Do you think the problem is Sarah Boone?
At some time, you've been through 8 or 9 relationships, and it's always them. Maybe it's not. I was thinking as she was talking, inside Ms. Cashman's head is messages.
Right. These 8 lawyers bad. No, they're not. We've seen in that incident with Sarah Boone.
All right.
They're going to think I killed him.
Why would they think that?
They always have said that. They've always have said that.
What have they
I
said?
told you it's because I'm the blue-eyed white dragon. That's what they call me. Because they don't want him with me. So he's basically just not really been around his family because he chooses me over them.
Welcome back to Court TV Live. Guess what, my friends? The White Dragon is in court this morning in Florida. There's a status check on her case because, surprise, surprise, she can't get along with her 8th lawyer. Patricia Cashman just detailed for the judge all of the efforts she has gone to try to have a good, healthy, professional working relationship with Sarah Boone. But according to Sarah Boone, that's not good enough. She wants the attorney to be nicer to her. She wants her to have a more loving demeanor when she talks with her. Let's go back in. We hit the pause button right before the break. Let's go back in and hear more. The defendant is addressing the judge as she's seated in the jury box.
To her, and then it turns into everything else. And then it turns into all these other different stories of why she won't do or why she has said certain things. It always changes when it mutates after I ask her for certain things, not just for the bond, but for other things also.
Okay, well, let's focus on the bond issue because you said that she's lied to you. And what you've told me so far, none of that is inaccurate.
Judge is like, yeah, that all tracks. That's kind of how it works. So where is the lie? Christy, yeah, my guess is if you've watched all this coverage, you would tell the court, hey, sorry, I saw her police interrogation. I saw all of her letters and her hearings, and I don't think I can give her a fair shake in this trial or whatever it may be that may get you out of this jury. Mostly peaceful. Can the judge eventually tell her enough is enough and review the evidence and rule on the case, him or herself? No. Nope, he cannot remove her right to a jury trial. Adam A's. So the world thinks she's a murderer or they agree with her. What is it, ma'am? Not sure she knows. Not sure she knows. Gringa. Could the judge assign a team of public defenders? No, they wouldn't assign a team. Definitely not in this case. He already has kind of assigned a team, right? 9 different lawyers. Deb. Peter, your dad said on a previous live that he would love to represent her pro bono. I think it was the second live you guys did. He should membership. I highly doubt it. I don't think that's what he said. And I'll tell you right now how my dad would and has dealt with clients like this. It's deuces. It's bye-bye. Even clients that have paid a lot of money, he's like, here's your money back. Goodbye. If they treated him like this, this early, obviously later in the case, they don't get the money back, but not many lawyers treat my dad like this. Now, sometimes there are disagreements. Sometimes they will, claim that he lied if he shows them some bad evidence. Again, he mostly handles criminal cases. It's very different than, most of what I do now. But there's some bad cases. There's some bad facts. There's some bad discovery that makes it very difficult to have these conversations with clients and hit them with the reality checks. But when they pay you a lot of money, usually they'll listen to you. It's like, why did you pick me? Why did you hire me? Why did you pay me all this money? If you think I'm an idiot and you think you could do it better yourself. I think the truth is, I'm not an idiot. And you couldn't do it better yourself. You just don't like the facts of the case. And that's okay. We can deal with some of them, but others we might not be able to deal with. And that means maybe we take this deal or work out that deal. Or do you have a witness you could call to refute this? Whatever it may be, you got to look at the case for what it is. There's no reason to ignore bad things that are going to come up in trial. She told my brother, isn't that hearsay? So hearsay is totally admissible and allowable in hearings like this. We're not in trial. Cleansed in fire. Blue-eyed dragon is from Yu-Gi-Oh. Okay. Susan, do you think she would trial and ask the judge to make the determination if she is guilty or not? Waive a jury trial? No, I don't think she would waive a jury trial. All right, let's get back into the hearing. And that she's still talking about bond. A very interesting part's coming up here about how do you think she would pay for a bond? Right? We know she can't afford an attorney. She's been sitting in jail all this time. How would she be able to post bond? Ms. Wild said, Peter, now say it lovingly. Say it slower and in a nicer, more peaceful, gentle way.
So how is it though, because I don't have any experience prior to this, I don't know the process of getting a bond other than what I have read, and it's just for her to do a bond, a motion for a bond hearing. But I didn't know that anyone, all of the other inmates, even officers, have ever said that they've had to do that process in order to have photographs taken, documented, and crews and visits to his house. He's not posting my bond, which I told her a million and one times, but she still spooked him by asking by him something that he's going to have to, and it would threaten his security clearance considering he's in the service, the military. So she totally deterred me from having my brother's address in order for me to have a motion for a bond. No one else is even his father, so you can ask me for one. And I will be honest with you and the court. I know for a fact that however sky high my limit would be for my bond to receive, I know for a fact unless my fans would set up GoFundMe pages or God's will or however else it is He planned on for me to have it paid, if at all, my point is to utilize my rights to have a bond.
Did you catch that? She says, I know my bond is going to be sky high if I got one. And I know I probably couldn't pay for it unless it's God's will or her fans set up a GoFundMe page. So if I'm the judge and I hear her say that, she's referenced the outside world multiple times, people watching, usually angrily, like everybody else knows about my case, the publicity's unfair. But now she's talking about letters from around the world, including South Korea, people agreeing with her, fans setting up a GoFundMe page to pay her bond. Now I would start to be careful and be a little frustrated and say, ma'am, are you trying to have these hearings and write these letters and do all this stuff to try to rally public support? Are you trying to use the public to pay or do things in your case? Because you've complained about it in the past, and we have to be careful to make sure we don't do anything inappropriate. Very interesting. She thinks she has fans that are willing to post her bond. And for those of you that think that's impossible, I will just tell you, go Google and research people getting married on death row, serial killers having lovers write them love letters. I think we've talked about it in other cases, even on this channel. Whew. Can you imagine that?
And with the information I have included in here to you, for the amount of saturation of publicity, there's nowhere that I could go, even if I were to be into a flight risk, because of the amount of information that everybody already knows about me, what I look like, and what I eat apparently, and so many other things. There's nowhere I could go if I were to even think about being a flight risk. It's just the fact that I would like please to have the bond so I can say that I've actually achieved something.
Okay, we're going to address bond in just a second, but let's back the truck up here for a moment. Did you guys hear what I heard? That she said, my fans? Did she say she has fans because she's gained notoriety?
I mean, I think she probably does have fans, if you want my honest opinion. I don't know if any of them are in the chat today, but I think she probably does have fans because wild stuff happens in the world today.
By being a defendant in a homicide case? The homicide of her boyfriend? Did she just say she has fans? Let's go back into the courtroom and listen now.
Never told me he had to provide pictures or deed to a house. What it said was, I mean, he's been in the courtroom for all the hearings, and it's likely that they would be here for the bond hearing, and that your face could be on the television, and it was a concern for him. And I'm
She's basically saying, I told her brother there's a worst case scenario that doesn't look good for you with your reputation and in the public because people are watching. Some people don't like your sister. The same could happen for me, but I'm a defense lawyer and I get it and I'm willing to take that risk. Make sure you are too. That's what lawyers are supposed to do, is tell you about possible worst case scenarios. Doesn't mean it's going to happen. Doesn't mean it's guaranteed, but it could happen.
gonna just leave it at that. But Judge, I can't spend all my time defending what I'm doing and at the same time be effectively preparing a case for trial. In these situations, I know it puts the court in a very difficult position. As I see it, Ms. Boone has a couple options. Number one, she can ask you to represent herself. She has the right to. You have a Feretta hearing and determine whether she's capable. The court then has to address the issue of whether it's appropriate to appoint standby counsel. Obviously, since she believes not a word that I say after 40 years of doing criminal defense, I'm probably not the right lawyer for that.
So she says, I've been doing this for 40 years. She doesn't trust anything I say. Maybe she should represent herself, and the court should have that Feretta hearing and determine if she should represent herself. And then if you're going to appoint standby counsel basically sits at the desk if she has questions or she can assist a little bit, but she's going to handle it herself. She's going to put on her defense. She's going to make the arguments. She's going to ask the witnesses questions. That's how she thinks it should happen. That's up to the court. But this lawyer kind of seems to think maybe that's the best route for Sarah Boone. Problem for everybody is Sarah Boone has not requested to represent herself. If she did, I think that's kind of the easy out for everybody. But at this point, she hasn't.
The other thing is she gets one last lawyer, it either works or it doesn't. And, and sometimes, unfortunately, the court gets put in a position that you have to have that conversation with a client that you don't, if you want your counsel of choice, then you need to hire your counsel of choice. And
why don't your fans, instead of raising money for a bond, why don't they raise money for counsel of your choice? Maybe that's how we solve this problem. But if you're not going to do that, your options are limited. So make it work or you're going to represent yourself. They've got to lay down the law at some point. This judge has to draw a line and say, I'm not blaming him. He's an awesome judge. He's an awesome guy. I get it. And no judge wants to do this. But at a certain point, you got to say enough is enough. And I think 8 lawyers is enough. So I think he could, if I were him, I'd say make it work with Miss Castor, I think her name is. Make it work with her or you're representing yourself. That's your decision. If you decide to ask to cut her, then you are asking to represent yourself. Give her that ultimatum and let her make the call. Now, the problem is she's already set up appellate issue saying she's prejudiced. She's not getting a fair trial. She doesn't like her. She disrespects her. That makes it difficult. IDK James. Peter, has credit for time served ever been sentenced in a murder case in Florida? Feels like we may reach that point. No, not that I know of. Wouldn't that be wild? It's like you've been sitting there long enough, ma'am. You can just go home. Guilty or innocent, you've served your whole penalty.
Everyone can certainly do that. And if you're indigent, the court can only go through this so many times with Miss Boone coming to the court and there ending up being irreconcilable differences such that the counsel that you have appointed can't move forward and provide effective assistance to counsel.
Okay, here's what we're going to do. I'm inclined to go ahead and figure out.
Patricia Cashman is
So
right.
This was when I watched this the first time. I was like, seriously, we missed what he said he's inclined to do. We get the gist of it at the end of the hearing. There's still like 5 minutes left. So we get the gist of it. And I think I can read between the lines and kind of guess. I haven't seen the order yet or anything, but I think I have an idea of what he's going to do, even though we have this whatever pause in the middle of it.
As an obligation under the law, when you sign up to do criminal defense work, to provide effective assistance to your client. Lawyers can get in really big trouble with that. I mean, cases can be overturned because of ineffective assistance. Someone could lose their law license if it's really bad, depending on the circumstances. And as you can see, that's not the case here. There's nothing ineffective about what Patricia Cashman is doing. She told the court 42 years she has served and practiced criminal defense work.
I will just throw out, just because you've practiced 42 years doesn't mean you can't be ineffective. But I agree that I don't see any evidence of her doing anything that's ineffective.
Any defendant would be lucky to have a seasoned attorney like that, who does, by the way, appear to be very nice and pleasant. As the judge noted, no lies are being discovered here. Just so you know, my friends, our video signal has been taking hits. That's why I'm coming out here a little more frequently and sharing some of my analysis with you. We're good. We've got the video back. Let's go in together again.
My last week.
Let me answer a couple questions before we get to what the judge is going to do in this case. Gingy Probs. I used to help clients respond to employer discipline and had Sarah's. Even if they had grounds, it was very hard to want to help. Advice for these. Yeah. So what I would say is that's when you put your hat on that you're helping people as a whole, and you're also helping other employees that might have the same legitimate problems that these difficult clients, I'll call them, have. So you're writing the letter for all of them as well to fix what that issue is, so nobody else has to have the same proper grounds for issues that this frustrating client can. And that's what I always say too, is I'm hammering the bad guys. I'm making sure other people don't get hurt, or that companies make safer protocols and procedures and they actually follow them. And it's going to help this person, but it's also going to help other. I try to find the best in people. Sometimes it can be difficult. Sharon said, do you ask about the win-loss record when seeking an attorney? You can. Problem is, I'm not going to say most attorneys lie, but it's easy to embellish. And I'll just say, like, for personal injury attorneys, for civil attorneys that do what I do, for me to tell you, I've never lost. I've won 100% of my cases. It's like, Okay, because most end in settlements and a lot of trials in state court, the plaintiff's supposed to win, the state attorney's supposed to win in criminal cases. So to say I've won every case doesn't necessarily mean that I'll win your case. It doesn't necessarily mean that I'm the best lawyer in the world, but you should win all your cases when you're me because you pick your cases, right? And if there are major issues, you usually tell your clients and you tell them, do you want to take the risk? Most of the time they say no, and they take a settlement amount that's worth it. And when we go to trial, usually we win. That's what I'm saying. I can tell you we've won every single state court civil trial we've ever done. But criminal cases, you're supposed to lose as a criminal defense attorney. The state has all of the resources and power, and they choose which cases go forward. So some really good criminal defense attorneys lose all the time, especially if they practice in federal court. Some of the best ones lose all the time because 90+% of trials in federal court, I think, are guilty verdicts. You do a little bit better in state court, but still. So looking at records or experience or results is more like they do a really good job for their client. They fight really hard. They hold the state to their burden. But even the best lawyer can't win certain cases, right? We know why. But the state attorney or the U.S. attorney respects those lawyers. So if they say something, they believe them, and that can help in plea negotiations or charging something lesser as opposed to overcharging. So all of that is important, but it's not just as simple as a win-loss record. Reese's mom, does everyone have a right to have a bond, as she says? So yes, you have the right to a bond unless there's an exception that, X, Y, and Z. If that happens, then you don't get a bond. So that's basically how it is in Florida. And they found that she met those requirements. Are there plenty of people who are not allowed a bond? I don't know if I'll say plenty, but there are people, yes. Nina, will the judge consider all her letters that to him during sentencing if found guilty? It doesn't seem to help her case. He may. I don't think he probably will. I don't think they'll probably reference that if we get to sentencing. Debbie, Peter, do you think Sarah will testify at trial? I think she will want to. Will her lawyer push back? Will she take her lawyer's advice? I don't know, but I definitely think she will want to. IDK James, Peter, I have a question. What happens if no attorney can represent someone? Is there any precedent for that? So there is precedent for conflict counsel for the public defender's office because sometimes they do have to conflict off cases, but then they'll have other people on a list that can be appointed and take the government pay, whatever that money is that they agree to, and represent people that are conflicted out of the public defender's office. But I don't know if I can figure out a situation where somebody would be conflicted off of every case. Maybe we're finding somebody that nobody wants to represent. Mama Wolf, when do you think the 58-page letter will be public? I have no idea, but I'm sure somebody will send it to me. Hopefully they do. I don't know why I even try with some of these. I know it's a stretch, but maybe she's leaning into insanity. Seems she's not all there, or at least doing her best to look at it. I don't think so. They haven't pled it. In Florida, you got to plead it. You got to have experts. Now, battered spouse syndrome is something they've kicked around. I don't know if they're going to actually go with that. Netwoman, weird, not really. She says fans and not people whom are supporter. So they're fanatics about someone slowly ignoring another suffocating in a suitcase. And she says it was an accident. Peter, hope you cover her 9th and 10th lawyer too. Thank you for the multiple daily lives. Netwoman, thank you for the super chat. I hope not. I hope we don't have lawyers 9 and 10. We need to get this case to trial. Enough is enough. It's been too long. Let's get this case to trial. All right, let's hear what the judge is going to do to try to get this case to trial.
Of my period is the first.
So when it cuts back in, he's talking about his trial calendar now. When he has trial set, and they're going to discuss everybody's kind of trial calendar.
Week of August, and it starts again on the last full week of August. So we could set it then, but I know that you have trial case management with Judge Marquez on the 20th or the 21st of June, which may impact that. So,
And I have a trial certain with Judge Harris August 5th, and
as do I.
Usually a trial certain means a date certain, meaning it's going to go. It's already been a continued amount of times. Everybody's ready. Everybody's set. We absolutely are going to go get all the witnesses ready. Tell the client it's time to go. Could be a capital case, whatever. Maybe date certain means can't schedule anything else then because I will be in trial then, as opposed to most trial dates, which you guys are all learning, are kind of like the salary cap in the NFL. Does it really matter? Does it really exist? If you can go over it and you can rework deals that you made before to lessen the cap number, does it really matter? Trial dates get continued or thrown out all the time for a million reasons, to my frustration.
August seems a bit difficult for me.
For a week, for Mr. Robbins, okay. So The options that I see it are, we could specially set this for the week of August 26th, or we set it for the trial period beginning September 30. The hiccup with that first week of September 30 is we have a court holiday on Thursday, October the 3rd, which would limit us to a 4-day trial period, which I don't believe is not sufficient. So that would take us to either October 7 or October 14. So based on the court's trial calendar, that's what I've got available: August 26th, October 7, or October 14.
I think the October 7th or October 14th is more realistic, Judge. I know that Mr. Cacciatore has other trials too, and other things on other judges' pretrial dockets and those things.
We're specially set in July and in September. Mr. Cacciatore?
I think we can, I think October 7th is fine.
Okay, so here's what we're going to do. We're going to specially set this matter for the second week of the September 30 trial period, beginning Monday, October 7th. We will set this matter for trial case management on the 24th of September, right? On September 24 at 9 a.m.
So what they just did is they have picked a trial date in October for this case. And you might ask, how the heck is that possible? I thought she just tried to get off the case. If she's not even going to have a lawyer, how can they have a trial date? So what that tells me is the judge is going to take the information back, look through it, see what decision he needs to make. He may be leaning to, guys, you need to make this work, because if he's going to appoint another lawyer, there's no point in setting a trial date. Or he's going to tell Ms. Boone, if you really want this attorney out, you've got to represent yourself, which I think is kind of a tough sell too. But I think he's going to go back, think about what to do, put a trial on the calendar to try to keep stuff moving. But at this point, trial dates have not even pushed it as quickly as we all would want it to go. B. Gentry, how much money do you think she has wasted thus far? Oof, I don't even want to think about it. Thousands and thousands and thousands of dollars. IDK James, what would you surmise if every attorney you encounter conflicts off? What happens then? Worked in JAG for U.S. Marine Corps. Interestingly, it's on both sides. Never seen this through UCMJ. Works differently. Oh, it works a ton differently. Thank you for your service, by the way. It can't even compare with that. But a logical, reasonable person would see that maybe they are the problem. But we don't always deal with logical people. We don't always deal with reasonable people in these scenarios. So let's hear what else the judge is going to do, because there's something else coming that's interesting.
Oh, yeah, that's a good idea. We'll do you at 1:30 in the afternoon.
It's Tuesday, September 20th.
Tuesday, September 24 at 1:30 in the afternoon for our trial case management.
So my guess is if they're going to set another status hearing, it's going to be between now and September at the very latest. They'll deal with this issue in September, which obviously means we're not going to go to trial in October. But we'll see. We'll see if anything pops up between now and September. All right, but there's a little bit more.
Trial date certain on October the 7th. Deputy, if you could please.
Date certain means other lawyers don't put anything on that day. Don't put anything on that day because we are going to trial.
Grab the 2 packages of submittals from Ms. Boone. Oh, I thought it was 2 different envelopes, ma'am. Okay. I will review that, and after the review, the court will either issue an order or set this matter for hearing based on what it is that's been presented by Ms. Boone. Mr. Cacciatore, anything else we need to address this morning, sir?
Not with say,
Ms. Cashman, anything else we need to address?
Not that I'm aware of at this time, Judge.
Ms. Boone, is there anything else you need to bring to my attention at this time?
I'm grateful for your time. I forgive you for having to utilize it. But I really do hope that you review thoroughly what it is that I'm asking for from my attorney who's supposed to be representing me.
Defense counsel, anything? No, judge. Prosecutor, anything? No, judge. Ms. Boone, anything? Yes, judge, I actually do have something. So the judge had just said he's going to review what Sarah Boone has drafted and submitted, and he is going to make a ruling. either make a ruling based on what she submitted. If she submitted real misconduct by a lawyer, ineffective assistance of counsel, irreconcilable differences that are legitimate, then maybe he'll be removed or she'll be removed and she'll get a new lawyer, or he'll talk to her about representing herself. But if he does that, he's going to set a status conference, another hearing. So from my perspective, the judge is going to do his job, look at everything and make a call. And what does Sarah Boone say? Judge, I want you to thoroughly look at what I've submitted. Thoroughly look.
For the trial is supposed to be happening in October, late September. So to push these, I don't understand how I'm supposed to be able to go into a trial when I don't have what it is to probably defend myself.
Ma'am, I've asked for your submittals. I will be reviewing them. All right. Thank you. All right, y'all. Thank you very much. Have a great day.
She said she doesn't know how she can possibly go to trial with this lawyer and this legal setup. She does not want to represent herself. Doesn't seem like she wants to go to trial. It is starting to feel like she is trying to delay. And I haven't really felt that way through most of the time and reading the letters. It seems like she wants to push it. She wants this to happen. But eventually, what are we supposed to believe? Like and again, it's the same scenario I brought up before. If she wants to delay, and every time she has tried this same ploy, that's exactly what's happened. New lawyer, another delay, more complaints, new lawyer, another delay. And that's what she's after. Then why wouldn't she try the same exact thing that's worked over and over and over again for her? Why wouldn't she ask for another lawyer and try to delay the case? Right? I mean, it's over. It's over. This can't keep happening. If I was the judge, I would say, as long as there's nothing legitimate in her 58-page letter, which is kind of how I'd expect it, I would say, make it work with Ms. Castor, represent yourself, you make the call, we're going to trial in October. And you got 4 months. Ms. Castor, can you prepare for this trial in 4 months? Yes. There you go, Ms. Boone. There you go. Reese's mom said, can the victim's family attend these hearings and speak out about the delays? If they wanted to, my guess would be yes. They definitely can attend the hearings. And if they talk to the state attorney, the judge would probably let them speak about it. And you have to weigh that. IDK James. So what happens when they don't? They eventually are refused representation. So eventually the court can say, we have provided you with court-appointed counsel. They've paid for it. They've done their job. You have continued to refuse it. Your refusal is, in essence, your decision to represent yourself. Your decision to make it not work with every lawyer means you are deciding to represent yourself. So you can represent yourself. Now, the case law and the appellate courts wouldn't love that, but I'm not sure there's been a case where there's been 8, 9, 10 lawyers that have tried with one defendant and the defendant basically screwing the pooch on 80% of them. I know some of them had conflicts and real reasons for leaving, but it's getting to the point now where these lawyers are dropping like flies in just a few months of representation. And it's like when somebody calls us and they've already had 2 or 3 lawyers, it does make it a lot harder to take the case. It does make it a lot harder to jump in, right? And do like a revision surgery. Uncivil Laws in the chat. What's up, man? And he said, sometime around attorney number 5, I lost my patience for any further motions for a new lawyer. Yeah, it's like we all, as lawyers, want Sarah Boone to have effective representation. We want her to have court-appointed counsel. She has a right to that. But at a certain point, enough is enough. All right, let's listen and see if anything else happens in the last 30 seconds here.
Thanks, Judge.
Ooh, yeah, deep breath after that. I feel like I need some Tylenol. Let's hit the pause button here as Sarah Boone is escorted back to court. We'll watch this video. She exits the screen. Back to jail she goes. No adjustment on her bond. I don't know what she expects. This is a homicide case. Very rarely do we see somebody out.
All right. So that's it. I mean, yeah, she called her snotty, called her a liar, said she was mean, doesn't know why. Why can't she just be nice to her? Can she be more gentle? Can she be kinder in the way she does things? I mean, just she's starting to lose legitimate complaints, right? She used to have some legitimate ones. I called 17 times. My investigator called. My lawyer's not calling back, not talking to me. That's a legitimate complaint. Lawyer's not letting me see discovery, not preparing trial with me, not talking to me about trial strategy, not getting an expert we need. That's a legitimate complaint. My lawyer is not nice to me because she wants to talk about stuff I don't want to talk about. She wants to show me discovery I don't want to see. She won't give me medical records that there's proof with my handwriting that I've already seen. Not legitimate. So when you start complaining for illegitimate reasons, the judge and the appellate court and everybody, the public, looks at this case very differently. Yeah, the smile and the smirk walking out, starting to make me think she's playing for the cameras a little bit, maybe. We'll see. But that's all we got. I am going to break down Karen Reed, the motion that was brought up again in her trial that's going to be argued on Monday. I am going to do a breakdown of that. It's probably going to post tomorrow morning, like Saturday morning. So if you guys want to check that out, make sure you subscribe and hit that reminder bell. And at the end of this live, make sure you guys hit the like. I appreciate you coming out. Almost 10,000 people in here to talk about Sarah Boone. I really wish this case would go to trial. I am ready for it. This case has just dragged on, and it seems like nothing's happening. At least Koberger and some of those other cases, they're making steps. They're sharing discovery. We're getting experts. Stuff's happening. Kate P said she's your lawyer, not your BFF. I think that's a great comment to end on. And a lot of times lawyers can't be your friends. They've got to be your representation. They got to do what's right and best for you and give you the hard truth, right? It's like saying it's unkind for you to tell your son not to put his hand on a hot stove. It's like, no, it would be unkind for you to tell him not to. But guess what? Sometimes they want to do that. But you got to tell them the truth. Sometimes the truth can hurt. Sometimes the truth is protecting somebody when they don't know it. And it seems like you're telling them to do something they don't want to do, or that they can't do something they want to do. One last comment. By the way, sorry to anyone in the chat who unintentionally spammed YouTube notification with old videos. That was my bad. Please resubscribe. Okay. All right. That's all we got. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.